Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy, debt relief, Chapter 7, Chapter 13, all these wonderful things that the federal government put in place. Jesse, co-host, how are you, sir?
I'm doing great. How about you, Dave?
I'm doing fantastic.
It's a great evening, isn't it?
Oh, it's wonderful.
I know.
Let's talk about the debt relief, the great help that's available under the Constitution and all the laws under Title 11 of the United States Code. A lot of people have made themselves aware of them over the years, but a lot of people haven't. But what basically is Title 11 and what's available for consumers and individuals and families?
Well, individuals and families, we can start there. Basically, the two chapters are only going to apply are Chapter 7 and Chapter 13 to the general consumer. 13, consolidation or partial repayment plan. It helps you to keep assets that you want to keep if you've kind of gotten behind in some things. Or a fresh start, as most people call it, Chapter 7, when you've gotten really far behind the eight ball, and there's just no way to get out from under that. I mean, if you were to, and I talk to people and it amazes me all the time. If you have 2 or 3 credit cards, it really doesn't matter, and you just make the minimum payment, you're going to have a difficulty to take care of that. I mean, the smart thing to do is if you have more than one, is to pay which one off, Dave, if you can?
Pay the one with the highest interest rate off.
Exactly. But people just, but this one.
That one's got my points.
But this one, Dave, has, I mean, I only have a little bit on it. I mean, I could pay that off quicker, and it just doesn't seem to click. And unfortunately, we've gotten into a culture sometimes where, hey, we want what's beyond our means a lot of times.
It's a financial equation for a lot of people on how to pay it off. But let's talk about how they get into debt. You mentioned credit cards. That's probably the number one cause of fresh start bankruptcy filings. But you also have medical bills.
Yeah, something happens, something terrible.
Personal loans.
Personal loans.
Autos that have been repoed, and now they're coming after you for the deficiency, the difference between what you owe and what they received at the auction. You might have had a home that went into foreclosure. You might have had a divorce, an illness, an injury, a job loss. Job loss is a big one.
Yeah, because it's difficult, especially, and like you said, sometimes they're combined with the two, injury and job loss.
Right. And you may just be a bad consumer.
Yeah.
You want everything you see, and you'll pay for it later. That TV that you put on the credit card that's $750 might wind up costing $2,000 to $3,000 or even more thousand over the course of repayment if you let the finance charges get a hold of you. So it's very easy to fall behind, because there's all those different reasons that we just mentioned. There
is, and then you need to look at, and the credit card companies are very, very smart. I mean, hey, it's free enterprise here. It's America, and so a lot of times people get offered a loan or kind of a little bit of a line of credit for no interest for 12, 18, 24 months, depending upon what you're going to get, which sounds really good. And you know what? For the smart consumer, Dave, that's perfect, because there's nothing like using somebody else's money for free. Okay, credit card companies don't want you to do that. But those people fall into the minority, I believe, not the majority. And what people don't realize is if they don't pay off whatever that particular debt is, or that credit card, or that deal that they got going on, if you don't pay it off within that extension, that time extension of no interest, then everything from the very beginning gets added onto that, boom, at once.
We see that common with furniture, TV, jewelry,
appliances,
electronics.
Yeah.
What it is a lot of these furniture places, they're not making any money on the furniture itself.
They're counting on...
They're making money on the financing.
Right.
Okay. Yeah, that's true. Also, some people want to get that credit card with their favorite sports team logo that they're lured to on the TV, to have that come out of your wallet with Bears or Bulls or Blackhawks on it, and people get tempted.
You could buy a key that's got those same things on there, a lot cheaper.
Yeah. So let's say you're in debt.
Okay.
And it's to the point where you don't feel you can bail yourself out within 6 months. So you're just treading water, and it's going to be the same old treading water for 6 months, a year, 2 years. And someone finally says, look, we're going to start suing you. And you get a lawsuit, you get a summons, and you're worried about your garnishment on your job or your bank account getting frozen. You finally pick up the phone and call a professional who deals in this area, and they're going to tell you what you need to do in terms of requirements, which are what?
And not necessarily what you want to hear, okay? And it depends on what that specific situation is. Well, let's talk about, it hit me here. The one thing you don't want to do, okay? And people try this avenue first, and it's absolutely the thing you should not do, which is they take out the money from the retirement, which is protected, and now this protected money under any type of a bankruptcy is now, guess what?
Unprotected.
Unprotected now, okay, and subject to be equitable distribution there. And so they try to do that, and not only does that happen, but there's a huge tax penalty that they're going to get by taking that money out. Okay, so just understand, hey, don't do that. Call before you do anything like that. But
not only is it protected from your creditors without filing bankruptcy, but it continues to be protected as you eliminate your debt or reorganize your debt.
And so the first thing you want to do is you want to, I guess it's difficult for a lot of people to maintain a budget. A lot of people, it's interesting when I talk to them, we have them fill out a form. It's a pretty detailed form, but it needs to be detailed, David. It's not completely detailed, but detailed enough, because in order to be able to represent or to give advice sufficiently, you need a certain measure of information. And it is incredible how many people don't know how much they make. They don't know how much they spend. And after we go through everything and we have them fill that out, it's, okay, well, I'm going to tell you something you already know. You spend more than you make. Okay. But they don't have a clue.
Some people don't know the finance company for their auto.
Exactly.
They just put it out of their mind. They know how much they're supposed to pay, and it might be coming out of their account automatically, but they don't remember who it was with.
Right.
If they have a mortgage, that often changes. They don't know exactly what the payment is amount.
Right, because when you say that the mortgage, what happens is a lot of times, and even right at the closing, we talked about real estate a couple times here in the past, but a lot of times at the closing table, when you're signing all those lender documents to get your loan, depending upon the type of loan and everything else in the lender, they will sell the rights to servicing, or they'll even sell the loan right at the table. You're signing a document that allows them to do that. Or sometimes they'll keep it, but they will transfer the servicing of that to somebody else. It's important to know who you're paying this money to.
Sure, absolutely.
So after, you really need to be aware of what you're doing and what you're spending. A good way sometimes to do that is to just kind of write some stuff down. But now it's too late because you're in this situation.
Yeah, now you want to get out of the debt.
You want to get out of the debt. So
worry about the budgeting after you get the fresh start.
So it depends, again, on a specific situation, whether or not you have a house that you want to keep, whether or not there's any equity in the house. Let's just take, I'm just going to throw a scenario out there. Okay, somebody in your example, okay, he's got behind, it's been a while, he's robbed Peter to pay Paul, which essentially means, and a lot of people do that, they'll transfer and shift balances from one credit card to another. Now, they have certain terms and conditions. Some, okay, if you do a fresh credit card, yeah, they'll allow you to do that. And then we have the same problem we were talking about in terms of, okay, after that time period's up, all of that, plus there's additional fees for the transfer and everything else. But hey, they're trying to stay afloat, so they're transferring them kind of back and forth. So let's say you have that. Let's say you have a house with maybe not a whole lot of equity in your house and a ton of debt. Now somebody's getting ready to sue you, like you said in your example. And the thing with a judgment, and a lot of people, you got to be careful because creditors, we have the Credit Protection Act, and a lot of creditors will, or the people that they get to call you and hound you, they'll hound you at home, they'll hound you at work, they'll hound you on your cell phone, and realistically, all you need to do is to tell them not to contact you again. And, well, by law, they're not allowed to, but that doesn't mean they won't. The only way they can legally contact you is to let you know and contact you to let you know that they're not going to contact you. To me, that was so amazing.
But they can still just go ahead and file suit.
They can go ahead and file suit, and then, but they'll also tell you things about, oh, I want to put this against your, well, hey, they need a judgment first to be able to levy anything against somebody's house or their bank account or garnish or their wages or anything else like that, which requires getting served and then going into court and the judge making a decision on whether or not you owe it. A lot of times what you'll see, depending upon, usually it's small claims, a lot of these things are under $10,000, which is the for the small claims court. And the judge will ask people when they come up there, do you owe the money? Do you agree or not agree? Okay, yeah, I owe the money. Okay, well, they'll pass it so you could talk with the creditor's attorney to try and make some type of payment arrangement. Okay, and so that's a possibility too. It just depends on your unique situation, how much you kind of got going on.
Yeah, there is one exception if someone signs a voluntary wage assignment. Those could be submitted to your employer, and you really don't have a defense to those under the Act.
Right, to be able
to be honored.
To be able to take care of that.
Right.
But a lot of times, though, when you have a voluntary wage assignment that you haven't, there's no lawsuit or anything else pending, and you've just like like maybe one of those title or the loan places.
Payday loan?
Yeah, payday loan. Thank you. Where you can stop that actually.
Depending. There's some
right.
intricacies there.
But the bottom line is, okay, and a lot of people, you have to understand too, hey, if we're a situation and somebody comes in and you're paying child support, Dave, and you're really not making a whole lot of money or anything else, there's nothing for somebody to take.
No, but you still have the harassment. You're
still
still getting the phone calls. You're still getting, the job is still knowing about this.
But you also have the possibility of them levying that judgment, placing that lien against your house at 9% interest. Even if they can't garnish your wages, if they try to garnish your bank account, there is a $4,000 exemption that you could use. So if you have $4,000 or less, and they've latched onto that, you can go in and get that knocked out because that's the exemption you have. Anything over that, that's going to be a little bit different.
I'm kind of surprised the state hasn't reduced that interest rate on a judgment. It's been 9% for a really long time.
You don't get 9% anywhere. I don't know for anything, right? I mean, what is it for a general bank account? What is it, like 0.5% or something like that?
1/10 of 1%.
Yeah, right. But I mean, that's what it is in terms of in judgments. And a lot of times they can really build up, and that could be even more than the principal amount. Now, since we're talking about judgments, and we're talking about bankruptcy, but people who owe child support. So each event of child support is a judgment. It's considered a judgment. So let's say you're supposed to pay, let's just say $1,000 a month. Okay. And okay, you pay it, no problem. But you don't, and you have this arrears. So each arrears of that is a judgment, and so that continues to add up, and all of a sudden, you have people who, which you can't discharge, and so all of a sudden now they're $30,000 in arrears for something that they could stand top on. But getting back to the bankruptcy,
someone needs to file.
Right, they need to file.
They've made the decision. They need to file. They understand that there's some pre-filing requirements that they must satisfy before they can get the official relief. What are some of those?
Well, you have to take a debt management class, right? That comes actually afterwards.
Credit counseling.
Credit counseling. You have
because you've been so bad with credit
right.
that now you need to be counseled on it.
Well, but the
pre-filing
credit counseling that you take is I mean, it's not going to. You're not in this position because you didn't have credit counseling, but they just try to tell you or see if, okay, hey, you could pay your bills or whatever it is. It's just another hoop to jump through. Didn't always used to have that until they revamped everything. So you're going to be required to do that before you file, because if you file a second before you've completed that case, what happens, Dave?
Well, it's an invalid filing. It's basically void. And the
Do you get your money back?
No, you've lost your filing fee.
How much does it cost for Chapter 7, Dave?
$335 at the time of this airing. And it's only going up.
Everything is going up for your Chapter 7. And then after you complete your voluntary petition and everything else, your creditors will get a notice from the bankruptcy court, or sometimes if somebody's doing a garnishment or they're threatened a garnishment, or there's a court date pending, even though they haven't obtained a judgment, sometimes the bankruptcy attorney will send it out to the creditor to let them know, because they're not going to chase after something that's just ridiculous. I mean, chase after some bad money here that they're not going to get.
The clerk will send notice within about 5 to 7 business days, but often as the attorney for the debtor, if there's urgent situations, you want to get that information out to stop any kind of garnishment or court proceeding, bank citation.
Right away.
Sometimes the bank account's already frozen, unfortunately.
Well, and then it takes a lot to go through to be able to kind of undo that. But
it could take 110 days if the creditor doesn't voluntarily file something or release it.
Right. And we've learned about that not too long ago there, and again, different situations what people do. But in this particular case we're talking about, if we have a house, and you can file, that's a common misconception. People who have a home can file a Chapter 7 bankruptcy, which is a fresh start, if they don't have too much equity. Now, Dave, what's the amount of equity?
Well, an individual can maintain $15,000.
Each. So if you're married,
That would be $30,000 worth of equity.
but if only one of you is filing, it's the 15.
Yes, well, they have to
For you.
give the
Right.
50% interest to the non-filing
Right.
spouse.
So $30,000,
opinion.
in your opinion, right?
Yeah.
So $30,000. Okay, so
Yeah,
well, that's not. So you can have at least $30,000. Actually, you can have more equity than that because
could.
if the trustee is going to try to recoup some of the equity from your house to satisfy some of your creditors, he's going to have to what?
There's a cost.
Right, he's going to have to sell the house. He's not going to get out there and sell it. He's going to employ a realtor, and that realtor is going to get 5 or 6%. And so, depending upon the value of your house, that can add up to another $10,000, $12,000, $15,000.
You also have title expense.
Attorney's fees.
You also have the fact that the trustee has to pay tax on the amount they bring in, which also reduces the amount available to creditors. So it's another reason why there better be a surplus. A trustee better not be selling a house just to give you your $15,000 and nothing else. There's got to be something for the benefit of creditors.
Right.
Otherwise, the court can undo the sale
'Cause
or
there's-
not approve it.
Right, there's no point in doing it if it's not going to benefit the creditors.
Right. Well, some trustees are a little bit deviant and just want to, cause some problems for people, and this is where we have to fight back.
Sometimes that happens, and so when that happens, then okay, so now you could file for your house, and then some people also are very concerned, Dave, about their automobile because here's the deal. Listen, I wish I had a newer automobile, but this is what I got. This is what takes me to work. This is what helps me pay the bill. There's no way I can get to work without my car. So if I file bankruptcy, Dave, am I going to lose my car?
You might, depending on how much equity you have in the car, but honestly, in most cases, there is not significant equity.
Usually, you're upside down in your
You're
car.
upside down, you're even if you're lucky.
Right.
And sometimes you might have a paid off vehicle, but we can protect up to $2,400 in a vehicle, plus there's a $4,000 miscellaneous wild card exemption that we could sprinkle over that. So you can realistically, $4,000 to $5,000 you can protect in a car, which usually does the trick.
Yeah, well, a lot of folks, again, they just don't have that kind of equity. I mean, when you think about it, even if you had a brand new car, and what do they tell you, and what is the truth? Brand new car, $50,000 car, Dave, when you drive it off the lot.
Yeah, well, you're going to lose a lot of equity.
You're going to lose a lot, right?
It's not
So
50%. but
well,
it's all-
no, it's not, but it's certainly a lot. So generally, what I find are people are, they don't have any equity in it. Generally, they're upside down, realistically. So
Well, they can reaffirm the debt on it. I think that's what you were alluding to.
Right.
They can agree to go back on the hook for that debt after the Chapter 7 filing technically wipes it out. They can sign on the dotted line.
But what does that
reaffirm the
mean,
debt.
though? I told you I was just upside down on it. But what happens if I change my mind later after I've reaffirmed?
Well, you do have some time to rescind, get out of the reaffirmation agreement, but you have to do it timely. And I believe it's either upon discharge or 60 days after the agreement was signed, whichever is later. So it's a little tricky, though. But know when you sign and go back on the hook for it. Know what you're doing. That's your decision time, really.
That's the end of that story then. So after you do that, and the same is true with the house too.
Yeah,
If
well, the
I-
house you won't reaffirm. You'll just continue
Well,
to make regular payments.
Right, but if you were entertaining any ideas about just washing your hands of everything, now is the time
Yeah.
to do it. Okay, not to wait because you're gonna be stuck with it, and that's what it is.
Right. Now, what about the credit cards? A lot of people want to keep a credit card or that special card that they first got when they were 18. And you unfortunately, you have to tell them what?
Get over it. It is
They're gonna
what it
lose them
is.
all.
They're going to lose them all, even if you don't have. And there are people that say, "Oh, well, what if I just pay? I only have a couple $100s off. What if I just pay this off?" Well, now you're making a preference right before you're filing I don't think the trustee is going to do much for a couple $100, but even if you have a zero balance, a lot of creditors are hooked in, and they know to the system, and they know when somebody has filed bankruptcy. And so what happens, Dave, when they discover that?
Well, they're going to get a letter saying that charging privileges have been terminated. They had to wipe out the card even though it had a zero balance, so
Right.
it wasn't even listed. The creditor subscribed to services that provide bankruptcy information. So what happens at court? Because people know they have to go to court.
For the
For
bankruptcy,
Chapter
or for,
7?
oh yeah, well, right, the meeting of creditors.
What happens at this court date? Is it scary? Is it nerve-wracking? Is there a lot of angry people barking at them about getting out of debt?
Well, Dave, I think that in a bankruptcy meeting of creditors, there are a lot of angry people. Not that they're just necessarily barking at you, but it's more kind of an informal type of thing. And you have the trustee with, if you can believe it, a cassette tape recorder. That's what I've seen some of the other folks. I don't know if you've experienced other things, Dave. A cassette tape recorder, which is just, I don't even know where you could buy one now. Maybe eBay, but so they sit you down. You know, your attorney should go over it, and realistically, it takes maybe about 5 minutes or so, depending.
You said informal.
Yeah.
You're sworn in.
Yep. You're sworn in, but it's
And
more.
if you are not honest,
Right. Oh no, I'm not saying anything about. I'm saying
you're
there's a
under
difference.
Title 18 bankruptcy crime. So.
There's a difference between informal and a difference between fraud,
But
Dave.
it's a serious.
It is serious, but it's more informal. It's not like you have the judge dressed up in this robe on this high bench over here. It's somebody sitting at a desk across from you. And what they're going to do is they're going to ask you, okay, hey, is this your bankruptcy petition? Yes. Did you read everything? Yes. Did you disclose everything? Yes. And they might go through a couple of things as it relates to debt, as it relates to income. They're going to ask you what you paid your attorney.
Yeah. But I think it's fair to think of that person as the equivalent of a special prosecutor.
I don't know, possibly. I mean, hey, as
They
the
can
trustee,
ask for more documents.
they sure can.
They could scrutinize your tax return and ask you questions about your pay advices if they want to.
It certainly can. Generally, they don't. I haven't really seen so much. I mean, if there's a gray area, perhaps, but generally,
The
if
biggest
there's no
power they
assets,
have is they can make a referral to the U.S. trustee, who can then decide whether or not to try and undo your bankruptcy, not give you a bankruptcy, and if God forbid you didn't disclose something major,
Oh, right.
and you've done something fraudulent, now you are looking at a bankruptcy crime, and the Attorney General could file charges.
Well, that's just gonna, make everything worse for you. But I find that most people, hey, they're at least, again, we have them fill out the intake form. We get all of their documents and everything. I can't, I mean, you've got to do that for yourself. I've got to trust that, and they get counseled.
We were
that,
under
hey,
oath.
Yeah, you're under oath. But again, your attorney tells you, listen, you need to make a complete disclosure. But I find, though, Dave, I don't think it's like a special prosecutor. You want to scare people out there. Look,
I don't want them to file on their own. I think that's a mistake.
Well, no, I think that's a mistake too. Even before the law changed, but especially now.
That's when people lose property.
That's right, because they don't have an idea on
How to protect it
how to
and what's
protect it, what their exemptions are, what anything else is to be able to do.
I get calls after people have filed on their own, and the
To fix
trustee has already grabbed onto property, and there's really nothing I can do. It's like a crane that comes down and grabs on the property. If you call an attorney after the fact, you might be able to help facilitate how it's distributed,
Right.
or explain how it's going to work, but you just can't make a phone call or file a motion and get a trustee to get off of a piece of property that was vulnerable.
Right.
So
So
it's too late.
because you tried to save a couple bucks, now you've lost a whole lot more than a couple bucks.
That's right. So that's why I do caution people. It is serious, and that trustee has a lot of power.
Right. It is, and that's true. But for the
house out
most
from under
person,
you, Jesse.
well, that's true, Dave. But for the average Joe, I mean, you have your attorney, and you're there, and you're at this meeting of creditors. It's not a witch hunt or anything else like that.
No. It should be relatively simple.
It should
if
be
you've
relatively
had
simple,
good counsel.
right? If you have good counsel and you're prepared,
But that's true with anything, right?
that's true. 5 minutes, you're out of there, and generally, if everything is as is in the petition, then they're going to find that it's a no asset case.
I mean, if a client goes with you on a traffic matter, they should feel comfortable, right?
I would hope so.
Okay. But
Yeah.
if they go on their own, it's nervous city, right?
It is for a lot of reasons because people aren't familiar. It can be intimidating to be in. That's why I'm telling you with the meeting of creditors with the trustee. He's not dressed up in a robe. I mean, there's something about a judge dressed up in a robe on a bench that's a little higher than you. And again, you have that too. Okay, there's that power position because that's why the benches are higher. Okay, because the judge is, and that's kind of a subconscious kind of a thing. But in the meeting of creditors, they should be okay if they have the proper counsel and they have the proper
I'm usually eye to eye
preparation.
with the judge.
Well, you're a little higher, Dave. You're a little taller. So yeah.
All right, let's talk about if creditors show up, because you mentioned that the trustee's going to be asking questions.
Sure.
But it's a meeting of creditors. They all got a notice.
Right.
Some of them could be angry. It could be a family friend who lent money to the debtor and the debtor defrauded them, do they have the opportunity to start asking questions?
They do. You could have a crazy uncle or somebody or whoever.
I'm usually the crazy
And
uncle.
you are, and then to ask questions and stuff like that if it's a personal loan. Sometimes, and I've been on a couple of those to examine the creditor, and a lot of times people. The debtor. A lot of times people want you to go out there just because they don't have a fundamental understanding of if it's a no asset case and it's an unsecured debt, that's all she wrote. And so,
Well, sometimes a creditor is aware of property
or fraud.
that may not have been disclosed, and
Right.
they can whisper into the trustee's ear, hey, did he tell you about that grand piano that's worth $20,000 that doesn't look like it was disclosed in his personal property disclosure?
Or wait a minute, hey, you bought from our store a color television and an Xbox. Actually, you bought 2 of them at Christmas, and then New Year here, you just filed this. So what happened to that? Yeah. And I've heard some interesting stories. There were people who bought furniture. This is a situation where it was a long time ago, and I represented the debtor, and the creditor came in and asked about the furniture and everything else, and my client said that the cat urinated on it, and I mean, it was just, I'm, you never know what people are going to ask, but I mean, did that happen? I don't know. I mean,
It's been known to happen.
it's been known that that's true.
Animals are animals.
And they are, and you have to get rid of things. So that's what, like you said, what.
You know what the most dangerous animal is, right?
What's that?
Human.
Oh, you think?
Yeah.
I know. Well, but at least,
See the police blotter lately?
they probably,
Okay.
won't go on the couch. I don't know.
Yeah.
Yeah. So anyway, so that's why you'll have somebody to go in there, and it can be intimidating for the debtor. But if you have your attorney there, your attorney's there also to protect you.
Okay. In a couple minutes left, I want to go over a couple other requirements. After the case is filed, the debtor must take a 2-hour financial management class so they learn all about financing and insurance.
That's after the pre-one, Dave. They had to take one before.
Yeah, well, the government wants to make sure that they don't fall back into problems again. Doesn't necessarily mean they won't, but it's educational. It's not a bad thing. It's only 2 hours out of their life, and some people have found it to be helpful. So I'm not totally against that one.
Okay.
I'm a little against the first one because they already want to file, and it seems like an exercise just to have to go through the credit counseling.
What's the cost for that, Dave?
It's about $15. It's not
So
huge.
it's nominal. Okay.
Right.
Yeah. So, well, here's a couple of questions that I think people want to hear. How long does the whole process take from the date that you file it until the discharge, assuming
Well,
everything is
In
straightforward?
a Chapter 7, if everything goes well, you're talking about 110 to 120 days, depending on the county. You'll go to court after 4 to 6 weeks, the meeting of creditors, and then you're basically waiting 2 months for creditors who have an opportunity to object. We usually don't see objections, only in the rarest cases, and that's where someone has done something, usually fraudulent.
They've withheld something, they haven't disclosed something.
Or they've run up a credit card in anticipation of filing.
Right, which is fraudulent.
They knew they had a little room left, so they figured,
Right.
I'll just run it up.
Right, exactly.
That's a no-no. So there's a lot of things like that, but 110 to 120 days, start to finish. All your creditors should get a notice in the mail. They should start to understand that you filed. The call should stop. There might be a few bills that trickle in, but if you just send those to your attorney, they're going to be able to notify those creditors to get them to stop. And the great news, Jesse, is from filing until discharge, less than 4 months, you've got a new financial life.
Yeah, and here's the other thing too. Whenever you, when you're in this difficult financial situation, okay, not only is it difficult financially, but physically and psychologically and mentally, and also for the family too, for your spouse, for the kids. The kids are smart and they know, and you have all that pressure going on, and that's really not healthy.
Yep. Thanks, Jesse.
You bet, Dave.
We'll see you next time on Legal Action. Take care.